Derek Chauvin's trial continues. This is week 2. And the day started with the emergency room doctor that treated George Floyd. The first witness on the stand today was Dr. Bradford Langenfeld, and he was the emergency physician at the Hennepin County Medical Center who provided treatment to George Floyd. He's also the doctor that declared George Floyd dead last May, and he had testified that he believed Floyd's likely cause of death was asphyxia. We know that that is coming. This is the emergency room doctor. He obviously did not do the autopsy, but that's what he stated in his professional opinion. The doctor did go on to state that there's another name for death by oxygen deficiency, and that's asphyxia, which is commonly understood, the good doctor told the prosecutors upon direct examination. On cross-examination, Dr. Langenfeld said that hypoxia can be caused by many things, including drugs such as fentanyl, methamphetamine, or a combination of both. And as we know, and we anticipate the evidence will be forthcoming, that's exactly what George Floyd had in his system. Nobody's taking sides here. We're simply saying these are the facts that we anticipate coming out. It's no secret that the defense is going to say that the combination of the methamphetamine as well as the fentanyl in George Floyd's system was the cause of George Floyd's death. We'll see what a jury ultimately decides. The next witness on the stand was Minneapolis Police Chief Medaria Arredondo, and he said that he thoroughly rejected Derek Chauvin's actions during the arrest of George Floyd last May because it was contrary to department policy. Once Mr. Floyd had stopped resisting, and certainly once he was distressed and trying to verbalize that, it should have stopped, referring to the pressure on the neck. The chief went on to say there is an initial reasonableness in trying to get him under control in the first few seconds. But when there was no longer any resistance, and clearly when Mr. Floyd was no longer responsive and even motionless to continue to apply that level of force to a person proned out, handcuffed behind their neck, that is in no way, shape, or form is anything that is by policy. Now, on cross-examination, the chief, who was not going to give anything up easily, ultimately conceded that all of these policies cannot be read individually, that they have to be read in a totality of circumstances, and that they can change based upon the circumstances that the officer is assessing there. And that really, to go back and armchair quarterback the situation, well, is playing armchair quarterback. The chief wasn't going to concede anything. It had to be pulled out of him. But ultimately, the defense got the answers that they were looking for, that these policies are really in the discretion of the officer and that they change based upon the circumstances that change, right? Just like when an attorney gives you an opinion, that may change based upon new information that comes out, just like you have to address those policies. It's not verbatim. That's the law of the land, so to speak. It's subject to change and interpretation. That's what the defense was looking for from that particular witness. And frankly, I think the chief didn't help himself by constantly arguing with the defense. Just give the defense the answer of yes or no. Let the prosecutor get back up and clean up what you think that the defense hurt them on. That's what he needed to do. But like all things in life, ladies and gentlemen, there's an easy way and there's a hard way. And everybody, I swear everybody, always picks the hard way. Before we continue on with the docket, let's take a quick recess. Please go to CrimeTalkSearch.com, sign up for a background subscription service. You'll be happy you did. If there's anyone out there you were ever curious about what was in their background, now is the time to do it. If you're going to get involved with somebody, now is the time to do it. When you go to CrimeTalkSearch.com, you put in the name, literally millions of public records are searched, and a report is generated. And it's going to give you a report. If they have multiple social media accounts, you're going to find it. If they have multiple phone numbers, multiple email addresses, it's going to be found. And more importantly, you're going to get information regarding criminal history. Hopefully the person you're searching has none whatsoever. But if it's there, it's going to be found. You're going to get everything you'd want to know, whether you're going into business or whether you're going into a personal relationship. You're going to be able to find out the information you want to know. So go to crimetalksearch.com, sign up today. You'll be happy you did. The Lori Vallo Chad Daybell trial is being pushed back again. That's right. They said in a brief hearing Tuesday that they are not ready for the trial, which is scheduled in July. Mark Means, Lori's attorney, and John Pryor, Chad's attorney, asked Judge Stephen Boyce to delay the proceedings. A new date has not been set, but a hearing for pretrial motions has been rescheduled now for June 9th, which is the 1-year anniversary of when 7-year-old Joshua J.J. Vallo and 16-year-old Tylee Ryan, two of Lori Vallo's children, were found buried on Chad Daybell's property. Now, Chad and Lori have both pled not guilty to the felony related to the alteration, destruction, and sealment of the bodies of JJ and Tylee. Now, at this brief hearing, the prosecutor said that he and his new special deputized special counsel, Rachel Smith from Missouri, that they're ready to go for the July trial date. It's the defense that was asking for the continuance. So, Pryor said he has dozens of items to discuss with Mr. Wood and Smith before going to trial. He said that he also still needs to ask to move the trial from Fremont County and may potentially hold a hearing to ask Chad's case be severed from Lori's case. Duh. I told you Chad wants a separate case from Lori Vallo. It was Lori Vallo's attorney that wanted to join it with Chad's case. I can't imagine Mr. Pryor wanted that at all. He's obviously objected to it, and he wants their cases severed. Now, back in October, Judge Boyce approved to try the Daybells together for efficiency purposes after Wood said he planned to use the same evidence and witnesses to prosecute the both of them. Now, if Pryor officially files a motion to sever, Boyce could order the trials to happen separately. Would somebody set a firm motions date in this case so that we can have a motions deadline? And unless you have good cause, you don't get to just keep saying, I'm going to file something. File it, okay? Now, the attorneys are basically saying there's just simply too much discovery to go through and that they can't get ready for this June 9th date or the trial date. The courts has a busy calendar, so they're going to have another hearing to set an actual trial date. I would say that if these attorneys don't think that they can be prepared, they need to either A, stop taking other cases in their practice so they can focus on this and be prepared, or better start hiring some associates to help you get the work done. We go to school in the Derek Chauvin matter, right? Day 9, and it has been expert testimony. Doctor. That's what it consisted of. And let's be honest, this was not a good day for the defense. This is sometimes, as a defense attorney, you think you're doing okay, you're holding your own, and then it all starts coming in. So who did we hear from today? First, we heard from Dr. Martin Tobin. He was a physician in pulmonary critical care. We heard from Dr. Eisenschmidt, a toxicologist, and Dr. Schmack, who was another forensic pathologist. So, what does it all mean in a nutshell? First, let's talk about Dr. Daniel Eisenschmidt. He is a forensic toxicologist at the NMS Laboratories in Horsham, Pennsylvania. And basically what he was there to do was to talk about his analysis of Mr. Floyd's blood results. There's been lots of talk that there's fentanyl in Mr. Floyd's system, and he broke it down. We got an expert class on drugs, how they metabolize, what remains the metabolites, and what it really means. Dr. Eisenschmidt went on to basically opine that he has analyzed some 7,000 to 8,000 cases a year at his laboratory, and that they tested George Floyd's blood, but that the numbers really weren't that high. Basically, they're saying George Floyd's numbers as it relates to the fentanyl in his system and the methamphetamine is basically the equivalent to driving under the influence of drugs, what they found when they analyzed those types of results. Mr. Nelson, the defense attorney, cross-examined Eisenschmidt, focusing primarily on the rate of metabolism of certain substances in human systems. Eisenschmidt said that the different drugs do process through the body at different rates. What is that supposed to mean? Clearly, the defense theory is that George Floyd had consumed fentanyl some prior time and then ingested it while he was in the backseat of the police car, or simply just prior to that, as was discovered when they went back and searched the police cruiser later on, and they found the fentanyl methamphetamine pills with George Floyd's DNA on it. Obviously, the reasonable inference from that was that Mr. Floyd's must have dropped that into the police cruiser at some time after his arrest. He certainly didn't do it. Again, he never had the opportunity. Why? Because he was dead. So that's the defense theory. The real issue then is going to come down to, was the level of fentanyl in his system, George Floyd's system, enough to kill him? Now, everyone today, and this is why it was kind of a bad day for the defense, was that the answer is no. Now, specifically, we also heard from a Dr. Martin Tobin. He is not a pathologist. Like I said, he's a physician in pulmonary critical care. And although the defense tried to make a couple of points on cross-examination where they talked about this wooden chest syndrome, which is a medical condition where fentanyl can create a rigid chest wall for some users, Tobin agrees it would impede the lungs. Nelson also asked Tobin if fentanyl can cause death by low oxygen levels. Tobin answers yes, but only in part. I'm going to assume that the defense has their own experts that are going to come in and contradict the experts of the prosecution. That's what this case is about. What killed Mr. Floyd? Was it Chauvin or something else? On direct examination, Dr. Tobin stated that a healthy person would have died if they were restrained as George Floyd was on May 25th, lying prone in handcuffs and with his knees pressing on the back of the neck, referring to, obviously, Derek Chauvin. The doctor told the court that he could tell by Floyd's facial expression the moment the life goes out of his body. A slow-motion clip of the widely seen bystander video was played in open court, showing the precise moment to the jurors. Tobin explained that because of his work, working in an ICU unit, he is familiar with watching people die. Unfortunately, Dr. Tobin also went on to explain that when Floyd gasped his last words, "I can't breathe," he still had oxygen in his brain. However, shortly thereafter, he suffered a major loss of oxygen, as evidenced by a movement of his leg captured on body-worn camera video. According to the doctor, bottom line is the leg jumps up like that as a result of a fatally low level of oxygen in the brain. While Tobin said that it's true that if people can speak, they can breathe, that's an unreliable motto. When you can speak, you are breathing, but it doesn't mean you are breathing 5 seconds later. The doctor went through and explained through a series of slides how lying prone with pressure on the back can significantly reduce breathing and oxygen reserves in the lungs. He also showed that when restrictions to the airway reach a certain threshold, it becomes a Herculean task to breathe. Needless to say, the prosecution played the video over and over again today to make their point. As we've said before, that is the worst piece of evidence for Derek Chauvin, is that video. And as I've said from way back, even a year ago, what's going to get Mr. Chauvin convicted is that smug look on his face when people are saying he can't breathe, and he almost looks as though he's enjoying applying pressure. Dr. Schmock was somewhat of a recap of everyone regarding breathing, pulmonary issues, and that probably the fentanyl was not enough to kill George Floyd. Certainly, the jury is going to have some tough decisions to make. We're going to have to wait and see what evidence, if any, the defense has. Remember, the defense has no burden to call any witnesses, but you would think that they would have experts to counter the experts that were put on today by the prosecution. Now, something's kind of interesting is that the prosecution is spending a lot of time with a lot of witnesses trying to prove that fentanyl ingestion by Mr. Floyd did not cause the death of Mr. Floyd. Now, the prosecution said this was a straightforward case and basically just watched the video for 9 minutes and 29 seconds. But the prosecution now has spent almost a day and a half trying to explain away the defense theory. Clearly, if the prosecution didn't think that it was completely irrelevant, not even close to being a defense that could work, the prosecution wouldn't be spending that much time on it. Just a little note, but at the end of the day, it was not a good day. The piling on by the experts saying fentanyl did not kill George Floyd or could not have killed George Floyd. Tough day for the defense for sure. This ought to get the old blood pressure pumping. That's for sure. Wait until you hear how long we have to wait to schedule something in the Lori Vallo matter. That's right. As you may recall, we brought it to you earlier the week that the defense had filed a motion to continue the jury trial, which was scheduled to begin in June. Well, the judge seemed a little frustrated because he had a busy fall. I'm not sure you can have such a busy fall. Apparently, a whole lot doesn't get done in Idaho judicial system. This case is over a year old by now. Most homicide cases are tried in a year. Homicide. The courts give people some time to get up to speed, investigate for a homicide case where someone's going to spend the rest of their life in prison. Here we have 2 charges, maximum penalty, 5 years each. So the defendants, Lori Vallo, Chad Daybell, are looking at 10 years in prison as charged right now if they were to lose on both counts. That trial should have been done on the first setting within 6 months, maybe one brief continuance to get up to speed. Now, I understand the defense needs time to prepare. There's a lot of information, but a lot of it is not going to be admissible. This simply comes down to whether the prosecution can prove that the 2 defendants, Lori Vallo and Chad Daybell, knowingly knew that they were somehow trying to hide evidence as it relates to the death of JJ and Tylee Vallo. The prosecution's ready to go because they understand speedy trial. They have 6 months from the date that the defendant says not guilty to get them there. The defense probably should do that as well. I can tell you, one of the best defenses is a good offense when you say, as a defendant, let's go to trial. Oftentimes, the government, I think I've described it like this before, is like a big steamroller. It looks harmless up front. It's a little slow getting going. But once it starts rolling, that's right. You don't want to be standing in front of it. The more time that the defense is going to give the prosecution to get ready certainly doesn't help the defense. Not sure what these 2 defense attorneys are doing. We call it the way we see it. I really liked Judge Boyce, but I'm starting to wonder if he has what it takes to really move this case along. Here we are a year out. Motions still haven't been filed by the defense. Are you kidding me? I mean, little here and there, disqualify the prosecutor, make sure I can see my client, but no substantive motions, no motions to suppress search warrants, no motions to suppress any statements that may have been made that we don't know about. Nothing. This is not that complicated of a case. The judge should set some firm dates and say the next trial date we set is going to be a solid date. Don't come back to me asking for a continuance. Don't come back to me asking to get off because those will be denied. Now, certainly the judge has to look at it at the time the motion is filed, but they can certainly put their foot down. Unbelievable. That's all we have for you today. Thanks for watching. Have a wonderful day.